Okay, so now we go to section 228, protesting of attachment. Now you have this PAN and you have this FUN, okay? The preliminary assessment notice and the final assessment notice. But before the PAN is issued, there is this what we call the letter of authority. You remember the authority of the commissioner to delegate his or her power. That's under section, I think, 7 here. Authority of the commissioner to delegate power. The power which we are going to discuss is the power to make assessment. That's section, I think, 6. Power of the commissioner to make assessments. Under section 7, okay, section 7 says the commissioner has the power to delegate some of the powers, okay, but except the following. So the power to make or to examine can be delegated by the commissioner, okay, and that is through the what we call the letter of authority. Now, when you receive this in practice, you should cooperate with the BIR because they have this power to inquire into your books. They examine the audit if what your accounting system is in compliance with the revenue regulations, etc., or if your accounting system is compliant with the law, you have not been hiding, you're not hiding anything from the government, tax evasion, etc. Now, after that, after the BIR finish the examination or the audit, tax audit, then they will issue a preliminary or pre-assessment notice detailing all the findings, the violations of the revenue regulations or the law. But under Section 228, PAN is not needed when you have to memorize this because I remember in one of the bar questions a few years ago when the multiple choice was still in employ, the examiner just changed one word here. I couldn't remember what, but then you have to just memorize this and all the others, the preliminary assessment notice or the pre-assessment notice is mandatory. Okay? So before BIR can issue a final assessment notice, there has got to be a pre-assessment notice, except in the following cases. Okay, so you have this mathematical error as shown in the phase of the ITR and is not needed. Discrepancy between tax withheld and tax paid by the withholding agent and is not needed. Taxpayers claims for refund or tax credit but actually applied such claim to his tax liability and is not needed. Excise tax due was not paid and is not needed. Article purchased locally or imported by an exempt person was sold to non-exempt person and is not needed. Do you remember the provisions in the VAT here? Now, uh, all the other cases, if the BIR finds out any violation of the law or any revenue regulations, then the commissioner should issue a preliminary assessment notice. In practice, well, as I've said, the BIR to the examiners or the division issues a letter of authority, and that is signed by, well, it's either the commissioner or his or her deputy, and it is delegated to the division, and the examiners will then go to your office and present that letter of authority, and that is their authority to examine the books. And you remember also that they have this third party rule, the what do you call this? The other one, the best evidence obtainable rule. Okay, so in the course of the audit, they have this substantially vast powers to ascertain the taxability of the employee or not the taxpayer. You remember that this assessment is already, or the taxpayer had already filed the return, okay, or the deadline for the filing of the income tax return or whatever return, the tax return, or the payment thereof had already expired. And if you remember Section 203, the BIR has 3 years to assess. Okay? Remember the Section 203, and you have also 3 years from the filing of the income tax return to amend. Okay? Now after that, the BIR, within that period after the deadline, the BIR has the power to examine if what you're saying is true or what you reported is true. Ay mga bakakon man kayo mo. So now, after examining, after auditing, the BIR should, okay, issue pre-assessment notice, except for the enumerated ones in Section 228. And after that, the plan should be in writing. Okay, there's this provision, Section 228. Just read that. Of what? The law and the facts. Otherwise, the assessment is void. Okay, in Section 228, here, within a period to be prescribed by the implementing rules and regulations, the taxpayer shall be required to respond to said notice. This notice is the pre-assessment notice. If the taxpayer fails to respond, the commissioner or his duly authorized representative shall issue an assessment based on the findings. Okay, so in practice, right now you have 15 days to respond to the pre-assessment notice. Okay, so it was prescribed by the revenue regulations as issued by the commissioner. And after that, if the BIR did not believe you, kay bakakon lagi mo, then the BIR will issue final assessment notice. Okay? And when you receive that, you may pay or you may protest. It depends. If the findings are unreasonable and everything, then you can protest. If the findings are true, kay bakakon lagi mo, then you should pay. Now, when you receive the final assessment notice, you have how many days? You have 30 days, okay, to file a request for reinvestigation or reconsideration. As we discussed earlier, you cross-read this with Section 222 B, C, and D, and Section 223. And you must be able to distinguish what a reconsideration and request for reinvestigation is. The request for reconsideration is just you reconsider all what was the decision of the findings, right, of the BIR without looking into other extraneous evidences. Whereas in reinvestigation, you may be allowed, or the BIR will have to look for other evidences in support of your request. And reconsideration does not toll the running of the period under Section 222 and 223. Okay, and reinvestigation again tolls the prescriptive period. Okay, so you just remember the distinctions between a reconsideration and a reinvestigation. Although this is more on the practical aspect of it, the practice in practice. And okay, when you ask for either, you have 60 days from filing of the protest to submit your relevant supporting documents. Okay, so when you receive a final assessment notice, you have 30 days to file your protest. You either ask for a reconsideration or a reinvestigation. And the effect of that, as I've said here, and from the filing of the protest, you have 60 days to submit your documents to support your arguments. Okay, and when you can go to the Court of Tax Appeals if the BIR denied or the lapse of 180 days given to the BIR had expired, or the 180 days had lapsed, okay? You take note not from the filing of the protest, but from the submission of documents. You read this here. The protest is denied in whole or in part, or is not acted upon within 180 days from submission of documents. Okay, this is it. The submission of, not from the filing of protest. Nah? You have, the taxpayer have 30 days adversely affected from receipt of the said decision or from the lapse of the 180-day period. You go to Court of Tax Appeals. Otherwise, the decision shall become final, executory, and demandable. So what is the effect? Then the BIR can now go after you. I mean, the levy, distraint, and collection suit. In this, there's a case, Fishwell Canning Corp. Versus CIR. This is what explained the difference between a motion for reconsideration and a motion for investigation. MR on the denial of the protest does not toll the 30-day period given to the taxpayer to file the appeal. Okay, I'm sorry. This is all about when you file an MR on the denial of the protest. This is another MR here. This is different here because when you receive the denial, you can actually file a motion for reconsideration there, but it does not toll the 30 days period here, right? This is, again, I repeat, this is different from the request for reconsideration here because you would take the risk of waiting for the BIR to rule on the matter. And the 30-day period shall begin if you receive that and you filed an MR. Or you either go to the CTA within the 30-day period. That's up to you. That's, again, it's a choice of the taxpayer, of course, through the lawyer. Now, in case of inaction, okay, if the BIR does not ignore you, the taxpayer has two options. It's either file a petition for review with the CTA within 30 days after the expiration of the 180-day period. You can go there, or you await the final decision of the commissioner on the disputed assessment and appeal such final decision to the CTA within 30 days after the receipt of a copy of such decision. This is the case of Lascona Land Corporation or Company versus CIR, March 5, 2012. These options are mutually exclusive and resort to one bars the application of the other. Okay? So, this one, you can wait. The final decision on disputed assessment, that's what they call FDDA. You can wait for that. Or if the 180-day period had already elapsed, upon, again, submission of documents, not upon filing of the protest. Okay, you have to master this rule here, class, because it is one of the favorite provisions of the examiner. You must master when is the PAN not needed, and the, the law or the taxpayer shall be informed in writing of the law and the facts. Okay, otherwise the assessment is void. And you have 15 days to respond to the assessment. Otherwise, the VIR shall issue a final assessment notice, the FAN. And you have 30 days from receipt to file either a reconsideration or a reinvestigation. So you remember, reconsideration does not toll. So if you file that, it would be favorable to you, especially if the prescriptive period is near the 3-year prescriptive period. Or you can file for a investigation. It does not toll the prescriptive period, but you would be given much leeway to submit documents and everything. And within 60 days from filing the protest, okay, you have to submit all your relevant supporting documents, okay, from filing of the protest, 60 days. Then you wait for the approval, the denial, or the lapse of the 180 days from the submission of documents. Okay, so Repeat, if you receive a denial, you can actually file a motion for reconsideration, but the 30-day period shall not fall or shall not be suspended. It's your risk. It's the risk that you have to take. It's either if after you receive the denial, you go directly to the Court of Tax Appeals. And in case of inaction, you have two options. You file directly with the CTA within 30 days after the expiration of the 180-day period, or you await for the final decision of the commissioner, and you're still given within 30 days to go to the CTA. And these options are mutually exclusive, and resort to one bars the application of the other. So you remember this, the rule here in section 228. Next, we will discuss section 229. This is all about recovery of tax erroneously or illegally collected. I hope you understand. I know by now you should have understood this section 228. Okay?